Hello students, my name is Abhishek Sudhir and welcome to the UGC EPG Pathshala for Civil and Political Rights and Module 13, the Right to Fair Trial under International and Regional Instruments. The right to fair trial is the single most important right in any democratic society based on the rule of law. The standards against which a trial is to be assessed in terms of fairness are numerous, complex, and constantly evolving. More often than not, they constitute binding obligations that are included in human rights treaties to which the state is a party. This module will deal with some landmark international and regional instruments that guarantee the right to fair trial. Amongst these instruments we will be looking at are the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the ICCPR, the African Charter on Human and People's Rights, the ACHPR, the American Convention on Human Rights, the ACHR, and European Convention on Human Rights, the ECHR. The purpose of this module is twofold. First, to give the students an overview of the internationally recognized components of an individual's right to fair trial. Two, to help the students understand the manner in which the right to fair trial is protected by some of the major international and regional instruments that have been passed by a majority of nations around the world. Now, the right to fair trial is widely recognized in international human rights law. This right is designed to protect individuals from the unlawful and arbitrary curtailment or deprivation of certain basic rights and freedoms. The most prominent of these basic rights and freedoms is the right to life and liberty of the person, a right that has been recognized in all of the instruments that we will be dealing with today. Let's start with the UDHR. The provisions of the UDHR were adopted and passed by the UN General Assembly on December 10, 1948. They are considered declarative of customary international law. What that essentially means is that because there is no sovereign at play, so this only constitutes as customary international law. So essentially, the Committee of Nations have agreed on a set of cardinal principles with relation to human rights, and they've given effect to those principles in the UDHR. Customary international law is often used as a supplementary source of a state's obligations in ensuring the right to a fair trial. What that essentially means is that, let us say India passes a law that curtails the human rights of its citizens, then India, as a signatory to the UDHR, has an obligation to adhere to the principles of the UDHR, even though the UDHR has not been passed by the Parliament of India, which represents the sovereign will of the people of India. Essentially, India gives up its sovereignty when it signs the UDHR. The provisions of the UDHR are therefore of great relevance for our purposes. Let's start with Article 10 of the UDHR. It was drafted by the United Kingdom and our very own country, India. Article 10 guarantees an individual's right to fair trial and reads as follows. Everyone is entitled in full capacity to a fair and public hearing by an independent and impartial tribunal in the determination of his rights and obligations and of any criminal charge against him. Let's reread that. Everyone is entitled in full equality to a fair and public hearing. So what that means is that everyone must be treated equally in the eyes of the law. They must get a fair and public hearing by an independent and impartial tribunal. You cannot have interested parties judging the outcome of the trial, essentially. And this fair and public hearing will determine the rights and obligations of that individual and the criminal charge against him. Here you were looking at a picture of Eleanor Roosevelt, who addressed the United Nations following the ratification of the UDHR. Eleanor Roosevelt played a key role in the drafting of the UDHR. Now we come to Article 11 of the UDHR. Article 11 deals with the presumption of innocence, a cardinal principle of the right to fair trial. Article 11 reads as follows. Everyone charged in the penal offense has the right to be presumed innocent until proved guilty. What that essentially means that the burden is on the state to prove that you're guilty of the crime. The state cannot arrest you tomorrow and say, well, you are presumed guilty. We think you're guilty. Now prove your innocence. The burden is always on the state to prove guilt according to law. So Article 11 says you're presumed innocent until proved guilty according to law, and you must have a public trial at which the defendant has had all the guarantees necessary for his defense. Article 11.2 of the UDHR deals with ex post facto laws. What is the meaning of ex post facto laws. These are laws that provide for the infliction of punishment upon a person for some prior act that at the time it was committed was not illegal. So let us say stalking or voyeurism, or for example, sexual harassment in India, till very recently was not a crime under the Indian Penal Code, was not an offense under the Penal Code. Once, let us say, on December 1st, 2014, somebody commits the offense of sexual harassment, but it's not an offense on that date. It becomes an offense on December 2nd. Then, in a trial on December 3rd, somebody cannot be convicted of sexual harassment or even charged or tried because on December 1st, sexual harassment was not a crime. Let's go through the section and then look at a couple of more illustrations that will help you understand the concept of ex post facto laws. Article 11, subclause 2 reads as follows. No one shall be held guilty of any penal offence on account of any act or omission which did not constitute a penal offence under national or international law at the time when it was committed, nor shall a heavier penalty be imposed than the one that was applicable at the time the penal offence was committed. Now, a couple of illustrations. Let's say A is arrested on July 1st, 2014 for defaming B in country Z. Defamation is only a civil wrong and not a crime in country Z. On August 1st, the Parliament of country Z passes a law making defamation a criminal offence. A cannot be tried for criminal defamation as it was not a crime on July 1st. The concept is very simple. Essentially, this prevents the state from going after single individuals. For example, let us say somebody finds a loophole in the criminal law and commits an act that is heinous and barbaric in nature, but nevertheless is not an offence under the current penal laws. That person cannot be charged or tried for committing that act at a later date when it is in fact an offense. Let's look at another illustration that will help you understand this. A is arrested for raping B on June 1st, 2014. The punishment for rape is increased from life to death in country Z on July 1st, 2014. A is convicted of raping B on July 2nd, 2014. The maximum punishment that A can be subject to is life and not death. It may be so that at the time of the conviction, the maximum punishment might have been death for committing rape. But when the rape was in fact committed, the maximum punishment was life, and the trial is governed by the law at the time of the commission of the offense. That is what the provisions against ex post facto laws guard against. Now let's come to the International Covenant on Civil and Political Rights, the ICCPR. The ICCPR is a key international human rights treaty. Provides a range of protections for civil and political rights. The ICCPR reiterates the provisions of the UDHR with regards to right to fair trial and equality before law and presumption of innocence, and also contains further detailed provisions on the elaboration of the right to fair trial. The ICCPR compels member states to take administrative, judicial, and legislative measures in order to protect the rights enshrined in the treaty. The ICCPR came into force in 1976 and 167 countries have ratified it and signed it so far. Under the ICCPR, in the determination of any criminal charge, everyone shall be entitled to the following minimum guarantees in full equality. They must be informed promptly and in detail in a language which they understand of the nature and cause of the charge against them. They have adequate time and facilities for the preparation of their defense and to communicate with counsel of their choosing. They have the right to be tried without undue delay. They have the right to be tried in their presence. They have the right to be present during the trial. They have the right to defend themselves in person or through legal assistance of their own choosing. If they do not have legal assistance, they must be informed of their right to legal assistance. They also have the right to have legal assistance assigned to them in any case where the interests of justice so require, and without payment by him or her in any such case if he does not have sufficient means to pay for it. What that essentially means is that if you cannot afford an attorney, an advocate, a barrister, depending on whichever jurisdiction you're from, the state has an obligation to provide you with legal assistance, a public pleader, as we say here in India. The member states also have to guarantee to the accused the right to examine or have examined the witnesses against him. He must have the right to confront his accuser and to obtain the attendance and examination of witnesses on his or her behalf under the same conditions as witnesses against him or her. What that essentially means is that they must have the right to confront the witnesses, basically. Now let's look at another aspect of the right to free assistance. One of that is the right of to have an interpreter if you cannot understand or speak the language used in court. This is an issue, for example, in a country like India. Let's assume somebody from Tamil Nadu is tried in Delhi. Then they cannot understand the language of the proceedings. Let us say they're in English or in Hindi. Then under the ICCPR, India as a signatory has the duty to provide an interpreter. And importantly, you cannot be compelled to testify against yourself. What that essentially means, the state cannot by law compel you to indict yourself. So if you have committed a crime, the state has to prove that you're guilty, and they cannot force you to hand over information or answer questions that would directly implicate you and result in your conviction. Now, let's look at the African Charter on Human and People's Rights. We've so far dealt with two international instruments, the UDHR and the ICCPR. Now we come to the regional instrument, the African Charter on Human and People's Rights, which is the founding charter as far as human rights are concerned in the continent of Africa. The African Charter entered into force on 21st October 1986. The charter has been ratified by 53 countries. Article 30 of the charter makes provisions for setting up an African Commission on Human and People's Rights. This African Commission on Human and People's Rights was established in 1987. So you have the charter and you have the commission. The purpose of the commission, according to the charter, is to protect human and people's rights and ensure their protection in Africa. Those of you who are familiar with international law will know that the means of enforcement is always problematic. Essentially, you need a body to enforce it. As the old adage goes, you and which army? Essentially, these are instruments of either international or regional groupings. International and regional groupings don't have the methods to enforce the rights guaranteed in these treaties. Therefore, you need a commission that will keep a check on member states. And when member states violate provisions of either these treaties or these charters, individuals, citizens of these member states can approach the commission in the case of the African Charter, or the Human Rights Commission in the case of the UDHR and the ICCPR, for the enforcement of their right, and in this case, their right to fair trial. And that's essentially the role the African Commission on Human and People's Rights plays. The Commission, however, can only deal with a matter submitted to it after making sure that all local remedies, if they exist, have been exhausted. This is very important. In international law, again, you cannot have international commissions or courts being the court of first instance. You cannot have a citizen of a country essentially saying that, okay, I will go immediately to the Human Rights Commission, I will go immediately to the African Commission on Human and People's Rights. However, the African Charter makes an exemption. It says, unless it is obvious to the Commission that the procedure of achieving these remedies would be unduly prolonged. Now, this gives the Commission a lot of power. What they're essentially saying is, if you don't have the right to speedy justice in your local country, or you do have the access to, there is a mechanism in place, but it would be unduly prolonged, then you can approach the Commission directly. Countries like Somalia come to mind, where there is absolutely no mechanism. It's a country that is essentially run by insurgent groups. So where are the local remedies? How do you enforce it against Somalia? There is absolutely no mechanism. But then you have countries like Sudan that have somewhat of a functioning state, which have certain structures in place, unlike, say, Somalia. So in a country like Sudan, ideally, the citizen should exhaust all local remedies in Darfur or wherever he's from in Sudan. But then that citizen can say, well, enforcing my rights would mean the procedure would be unduly prolonged, and exhausting all these local remedies would take an exorbitant time. Therefore, that citizen will say, well, I will approach the Commission directly for the enforcement of my rights under the Charter. So now let's come to Article 7 of the Charter. Article 7 of the Charter provides every individual with the right to a fair trial. The right to fair trial under the Charter includes the following: the right to an appeal to a competent national organ against acts violating an individual's fundamental rights as recognized and guaranteed by conventions, laws, regulations, and customs in force. The right to be presumed innocent until proved guilty. by a competent court or tribunal, the right to defense, including the right to be defended by a counsel of his or her choice. And now, this is an interesting one, the right to be tried within a reasonable time by an impartial court or tribunal. So the African Charter places an emphasis on time. You cannot have somebody rotting away in prison, is essentially what the African Charter is trying to say. The African Commission, in its 11th Ordinary Session meeting in Tunis, in Tunisia, from the 2nd to the 9th of March 1992, adopted something known as the Resolution on the Right to Recourse in Fair Trial, a landmark instrument. This resolution on the right to recourse in fair trial stated that the right to a fair trial under Article 17 includes the right to have their cause heard. Essentially, you have the right to have your cause heard, and you shall be equal before the courts and tribunals in the determination of your rights and obligations. The resolution also states that persons who are arrested shall be informed at the time of arrest, in a language which they understand, of the reason for their arrest, and shall be informed promptly of any charges against them. Again, in Africa, in a country, even in the individual countries, you have various dialects. People cannot understand one another. South Africa being a prime example, with languages such as Afrikaans, Swahili, and even English. So again, the right of an interpreter, the right to be provided rather, an interpreter, is key to the right to a fair trial, because you need to understand what you've been charged with. You need to understand what you're up against, essentially, so that you can prepare your defense. Persons arrested or detained under the resolution shall be brought promptly again time, before a judge or other officer authorized by law to exercise judicial power, and shall be entitled to trial within a reasonable time or be released. Persons charged with a criminal offense shall be presumed innocent until proven guilty by a competent court. Again, the presumption of innocence is something the resolution harps upon. And in the determination of charges against individual, the individual shall be entitled to the following. Under the resolution, he shall have adequate time and facilities for the preparation of their defense, and to communicate in confidence with counsel of their choice. Now, this is important. Not only do you have the right to legal assistance, but you have the right to have confidential discussions with your lawyer. You cannot have the state and the prosecution listening in on the manner and the nature of your defense and how you're preparing your defense. Again, you have the right to be tried with a reasonable time. You have the right to examine the witnesses who are testifying against you. And you have the right to also obtain the attendance and examination of witnesses on your behalf. And you have the right to cross-examine those witnesses, or examine in chief, as they say. Essentially, when it is your witness, you examine that witness in chief. That's called an examination in chief. And when it is not your witness, when the state is putting up a witness against you, you cross-examine that witness. Essentially, your job is to discredit that witness, because that witness is saying something that is adverse to your case. You also have the right to free assistance of an interpreter, as we've said. Again, the resolution reiterates some of the provisions in Article 7 of the Charter. And very importantly, persons convicted of an offense shall have the right of appeal to a higher court under the resolution. Now we come to Article 45C of the Charter. Under Article 45C of the Charter, the African Commission on Human and People's Rights has a mandate to formulate and lay down principles and rules aimed at solving legal problems relating to human and people's rights and fundamental freedoms upon which African states may base their legislation. So essentially, it's incumbent upon the Commission to set down broad guidelines, the broad contours of any human rights legislation that member states intend to pass. And they've laid down something known as the Principles and Guidelines on the Right to a Fair Trial and Legal Assistance in Africa. The African Commission, unfortunately, despite all these enabling provisions, is severely hampered by a lack of resources. And the Commission is therefore able to meet only twice a year for 10 days each time, a very limited period during which to undertake the protection of human rights in a continent like Africa, where there has been a history of human rights violations by often repressive regimes. Here, you're looking at a picture of individuals who are part of the toppled Gaddafi regime in the African country of Libya. These individuals claim that many of the rights under the Charter, like the right to a fair trial, are being violated under the new regime. Now we come to the American Convention on Human Rights, another landmark instrument in the Americas. The American Convention on Human Rights also known as the Pact of San Jose, was adopted on 22nd November 1969. The Inter-American Court of Human Rights is an autonomous judicial institution set up under the convention, and its purpose is the application and interpretation of the principles and the provisions and the rules contained in the convention, American Convention on Human Rights. The court exercises its functions in accordance with the provisions of the convention. The convention also sets up an Inter-American Commission on Human Rights. The main function of the commission, much like the African Commission, being the promotion of respect for and defense of human rights. Now let's come to Article 8 of the convention. Article 8 of the convention guarantees the right to a fair trial. Every person has the right to a hearing with due guarantees and within a reasonable time by a competent, independent, and impartial tribunal, previously established by law. Again, you see that a lot of these articles are repetitive, but that only goes to show the importance of the right to a fair trial and how the principles of a fair trial have essentially managed to be uniform across the world. It's one of those rights where achieving an international consensus has been very straightforward and simple. The enforcement of it by the member states is a completely different matter. So again, every person has a right to a hearing which guarantees within a reasonable time, with due guarantees when within a reasonable time by a competent, independent, impartial tribunal previously established by law in the substantiation of any accusation of a criminal nature made against him or for the determination of his rights and obligations of a civil, labor, fiscal, or any other nature. So here, it's interesting. The American Convention guarantees the right to a fair trial not only in criminal proceedings, but extends it to proceedings that are civil, labor, or fiscal in nature. And therefore, this is quite revolutionary. It extends it to matters that are civil in nature. Now, you have to ask yourself, why is it that the right to a fair trial only applies to crime or criminal proceedings in a majority of countries and a majority of the international regional instruments? Why isn't it extended to civil proceedings like it is under the American Convention? Well, the answer to that is very simple. When criminal proceedings take place, the outcome of criminal proceedings is often the deprivation of a person's liberty. Whereas in civil proceedings, that often the result is not a direct deprivation of a person's liberty. But the American Convention seems to disagree. They believe that the determination of an individual's rights and obligations of a civil nature or a fiscal nature are also serious enough to warrant the right to fair trial protection, basically. Every person accused of a criminal offense has the right to be presumed innocent so long as his guilt has not been proven according to law. Every person is entitled with full equality according to the convention to the following minimum guarantees. You have the right to be assisted without charge, again by a translator or interpreter, if he does not understand or does not speak the language of the tribunal or court. Again, in South America, although Spanish is widely spoken, with the exception of Brazil, where they speak Portuguese, you have several local dialects, and you have a lot of indigenous tribes people from, say, in countries such as, say, Bolivia, who probably don't speak Spanish whatsoever, and therefore they would probably need the help of a translator or an interpreter. Also, the convention guarantees prior notification in detail to the accused of the charges against him. The case against you, the accused, must be set out in detail by the prosecuting authorities. You also have the adequate time and means for the preparation of your defense. You, the accused, also have the right to defend yourself personally or to be assisted by legal counsel of your own choosing and to communicate freely and privately with his counsel. Again, we talk about this attorney-client privilege. Confidentiality is extremely important when you're preparing your defense. The inalienable right to be assisted by counsel provided by the state, paid or not, as the domestic law provides. And also, if the accused does not defend himself personally only, right, then you have the right to be provided with legal assistance. Again, all of this is repetitive, but it's worth going through because you as a student need to understand the importance of these principles. The right, again, to examine the witnesses present in the court, the right to confront your accuser, and the right to obtain the appearance as witnesses of experts or other persons who may throw light on the facts. You have the right to an adequate defense, basically. And again, you have the right not to be compelled to be a witness against yourself or to plead guilty. That's very important. When there's a presumption of innocence, the state cannot have a law where they essentially say that you have to plead guilty if you're charged for this offense. You also, of course, have the right to appeal the judgment to a higher court. And interestingly enough, a confession of guilt by the accused shall be valid only if it is made without coercion of any kind. You cannot have somebody put a gun to your head and say confess. That would be duress, because you're under pressure to confess. Now, Articles 8 in connection with Article 9 and 10 also deals with fair trial. An accused person acquitted by a non-appealable judgment shall not be subjected to a new trial for the same cause. What does that mean? What that essentially means is, if you're tried for offense A, and under the domestic law, offense A is non-appealable, and you are acquitted, then you will not be subjected to a new trial for the same cause. You need to understand the difference here between a right to an appeal for the prosecution and the right to appeal for a defendant. The right to appeal for a defendant, according to most international regional instruments, is non-negotiable. You must have the right to appeal any judgment, any finding against you which results in the deprivation of your liberty. But the same does not hold true when you are acquitted by a non-appealable judgment. Therefore, the state does not always have the right to appeal. The state does not always have to have the right to appeal. Why? Because the state is an entity. Its liberty cannot be curtailed. What you as an individual, when your liberty is curtailed, you have the right to appeal it. So what Article 8 says is, an accused person acquitted by a non-appealable judgment shall not be subjected to a new trial for the same cause. And again, criminal proceedings shall be public, except again, insofar as may be necessary, protect the interests of justice. Now, let us say it's a case of the rape of a minor. You do not want the identity of that minor. You do not want that trial, and you do not want that minor to go through the trauma of having to recount his or her horrors in front of a public audience. That's what Article 8 is trying to say, that yes, as a general rule, criminal proceedings shall be public, but in the interests of justice, they don't have to be public. And of course, the standard there is very strict. It's very, very strict. The interests of justice must outweigh the need to have a public hearing. Because at the end of the day, what is a crime? A crime or an offense is a crime against society. So when there's a crime against society, when you murder someone, when you as an individual take another life, society has an interest in seeing that you're brought to justice, seeing that you are, if need be, deprived of your liberty and life in certain cases, and you are sent to prison. When that happens, a public hearing is necessary, not for some sense of gratification, so that people can then see you being tried in public and they can humiliate you. No, justice must not only be done, but must be seen to be done. Essentially saying that you are having a fair trial. If you're acquitted, the public knows why you're acquitted because it's been a public hearing. If you're convicted, the public knows why you've been convicted because it's a public hearing. Further, Article 9 of the American Convention provides freedom from ex post facto laws, which we've already discussed, and Article 10 guarantees the right to compensation where a person has been sentenced by a final judgment through a miscarriage of justice. Now, again, this is a very interesting concept. If the state errs, then you are wrongly convicted. Let's say you've spent 10 years in prison. The fault is completely the state's and not of your own. It's a flawed judgment. There's been a miscarriage of justice. You are entitled to monetary compensation for the lost years of your life. Finally, we'll quickly look at Article 6 of the ECHR. According to Article 6, in the determination of an individual's civil rights and obligations of any criminal charge against that individual, everyone is again entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Once again, it is absolutely the same. We've been going through this throughout the whole module. These principles are so cardinal that almost every international and regional instrument reproduces them. The convention, the ECHR, says that the judgment shall be pronounced publicly. Again, harping back to the issue of justice being seen to be done. And again, says that the press and public may be excluded from all or part of the trial in the interests of morals, public order, or national security in a democratic society. Where the interests of juveniles, for example, you do not want juveniles, perhaps they have committed murder, but still, they're juveniles. They deserve the protection of the law. They have a right to privacy, or if not a right to privacy, the right to their identity being protected because they're, after all, minors. The protection of the private life of parties is something the ECHR, somewhat in the French tradition, places a lot of emphasis on. And the extent strictly necessary, in the opinion of the court, publicity would prejudice the interests of justice. That trial can then be held in behind closed doors. Article 6 also, again, reiterates the principle of presumption of innocence, and again, reiterates other principles such as being informed promptly in a language which you understand of the nature and cause of the accusation against you, adequate time and facilities for the preparation of your defense, again, the right to legal assistance, which we've already been through, and the right to examine or have examined witnesses against you, and to obtain the attendance and examination of witnesses on your behalf under the same conditions as witnesses of the state. And once again, you have the free assistance of an interpreter if you cannot understand or speak the language of the court. Been through all of this. Article 7 deals with ex post facto laws. Now, ex post facto laws does not prejudice the trial. This is very important. You need to understand that ex post facto laws do not prejudice the trial. The standard of proof, the burden of proof, these are principles of criminal jurisprudence that don't change from country to country, especially in the common law tradition. The United Kingdom, the United States, in India, where we follow the common law tradition, principles such as the presumption of innocence hold true. No law can ever take that away. No constitution can take that away, some might say. Right? So, the provision of ex post facto laws does not prejudice the trial. Ex post facto laws only deals with punishment for an act or omission which at the time when it was committed was criminal according to the general principles of law recognized by civilized nations. So, what they're trying to say again is ex post facto laws have absolutely no prejudice on the trial. The trial takes place. It's only the punishment that is at issue, basically. And you cannot, a greater punishment than what was punishment at the time you committed the offense cannot be inflicted upon you. So, to conclude, we have seen how some of the essential elements of fair trial, like the presumption of innocence, free and fair public hearing, speedy justice, and the right to legal representation have been codified in various regional and international instruments. We've in fact seen through this entire module how all of these principles are repeatedly stated in every instrument. What does that tell you? That tells you that these principles have universal recognition. The right to fair trial is at the very core of a democratic society. When you start depriving people arbitrarily of their liberty, then there is nothing really that can stop the society from spiraling into complete anarchy. As I've said, the fact that all major regional groupings of nations have recognized the paramountcy of the right to fair trial reinforces the contention that this right is an integral part of any civilized democratic society based on the rule of law.